A quick introduction on myself. I'm Michael Neumann, or Michael Neumann, as we say, where I'm coming from in Zurich, as this picture is showing. And we are a law firm based in Geneva with offices in Zurich, in Belgrade, and Dubai. I'm based in Dubai and Zurich, traveling there and forth, and supporting our clients in both jurisdictions. And as I said today, we're talking about money laundering and some of the topics that are around it. And when I mean money laundering, I do not want to talk about KYC issues or some forms to fill out, but I want to talk about the criminal aspects of it and some of the issues that I have encountered in my career, and I'm sure many of you also have seen. Thank you. So maybe let me quickly ask, who of you is in white-collar crime, or this topic is concerning you in any way? All right. So maybe we can come to some solutions, because I will sadly only present the problem with the proposed solution, but I do not have a final solution. Maybe you guys can help me find it. That we went through. So just a very quick summary of the money laundering. I do not want to bother you with things you already know. It's the act of making illegitimate funds seem legitimate, meaning proceeds that originate from a crime make them seem legal in order to spend them without danger. Money laundering is mostly described in this 3 stages model that was developed by the US Customs: placement, layering, integration. I will not get further in it because I'm sure you all know it. Money laundering, an act, first incriminated in the US in 1978. And back then, it was purely introduced in order to confiscate proceeds from drug trafficking. And with the years, it became more and more, meaning the offenses were extended to basically any crime and also to tax crimes rather recently. So what is always important when we're talking about money laundering is that we must always have a predicate offense that the assets that are being laundered originate from. I think that's always the important thing to keep in mind. After the introduction in the US, it was prohibited in basically all the states around the globe, and the commitment to fight money laundering has become more and more internationalized. I'm sure you're all aware of the FATF or the Wolfsburg Group that deal with it. However, sadly, none of the issues that I'll present, I have found anything on their respective web pages. Why are we even talking about money laundering? Why is it a big deal? Because according to the UN estimates, around 2 to 5% of the global GDP have been laundered or are laundered each year, meaning it's over $1 trillion that are somehow connected to money laundering each year. Just to give us a quick insight what the crime looks like, or what does it look like in a criminal code. This is the UAE AML Act from 2018, and it's basically the same all around the world. We'll see, as mentioned, proceeds from crime, and then certain activities that are done with these proceeds, meaning the money laundering activities, for example, transferring or converting the proceeds, concealing or disguising the true nature, acquiring, processing, or using proceeds, or just the assistant or assisting the perpetrator in these concealing actions fall under this AML Act. And it's the same for other countries. The classic money laundering activities are the exchange into a different currency, the transfer of these assets to an account abroad, the blending of these funds into a business, and that all makes it rather complicated to distinguish which crime or which proceeds are of criminal origin and which ones are not. So I wanted to talk about some unsolved issues when it comes to money laundering. And particularly, I want to talk about the issue of surrogacy, the replacement. So when we have criminal proceeds and they are laundered, the original value is replaced with another thing. For example, cash is replaced into a house. House is replaced into Bitcoin, etc., etc. So if we spin this wheel on and on, it could go on infinitely. And if we are thinking about that every time that money is laundered, these assets are contaminated, meaning of criminal origin, and that means they can be confiscated by the police. So if we spin this wheel and every asset that is touched between these transactions is considered contaminated, this means at some point our entire economy is contaminated by these activities and would be able to be confiscated. So we need to find some sort of limit in order to assume when does the surrogacy, when does it stop? And we'll look at an example to make this a bit more easy to understand. The second issue are the so-called commingled mixed funds, meaning what happens when criminal funds or from criminal origin is mixed together with assets from a clean origin, from a legal origin, and they're put together on the same account. As we mentioned before, money laundering is only when we launder criminal proceeds. But what is criminal? When it's mixed. Is everything criminal? A part of it criminal? None of it criminal? Those are some of the questions that have not yet been answered. Let's look at a very simple example, and it's a very oversimplification of the whole thing, but just in order to get the same understanding. Person A sells drugs to person B, receives 4 million dirham for it. In the next step, he pays the 4 million dirham and receives a house in exchange for it. In the third transaction, he sells a house and then he receives $1.5 million for it. So our 4 million dirham are the original criminal proceeds. They are the original, there's the original crime has brought these proceeds, and meaning every step that is taken with these assets is considered laundering. For example, in the first transactions, person A uses these assets to buy a house. Classic money laundering activity. Now, the house is the first surrogate of the original value. In the second transaction, he sells the house and receives $1 for it. Now the dollars have become the second surrogate of the criminal proceeds. We could spin this entirely. It can go on for 10, 15, or 100 transactions. In practice, it is far more complex. And this is just some of the examples that are used by money launderers. As mentioned, always different currencies are involved and mostly cross-border transactions. So, during the course of these transactions, as you have seen, there are many people involved. It's not just always one person. There are several people, and some of them are fully aware of the criminal origin. They're part of the scheme. They're helping to launder these proceeds, but some of them are unknowing persons having no idea of the criminal origin. So how do we deal with them? Do we confiscate their assets that they have acquired in good faith or not? And what of these surrogates can be confiscated by the police? And I'm just talking about the solution that we have discussed in Switzerland, which is also not a final one, by the way. It has not yet been confirmed by the courts. So in the Swiss doctrine, we say, as long as the surrogates, meaning the replacement of the original criminal proceeds, are in the economic sphere of the perpetrator, they still qualify as contaminated and they can be confiscated by the police. However, that chain of contamination can be broken if a third party acquires these funds in good faith, not knowing about the criminal origin. Let's have a look what that means in the example. So the first transaction is very clear. Both parties know about it, and it is anyway the predicate offense. It is not yet a laundering activity. In the second transaction, he pays the 4 million dirham to buy a house. It is now the house that is contaminated. It's the house that can be confiscated. But what about the 4 million dirham? of person C. So if person C, according to our Swiss doctrine, has no idea about the criminal origin of these dirham, about its drug history, the 4 million dirham are becoming clean if C has acquired them or has received them in good faith, did not know about it. Meaning they're out of confiscation and no more money laundering can be committed with these 4 million dirham. However, should person C be involved in this whole scheme, the 4 million dirham remain tainted assets and can be confiscated as well. And further money laundering activities can be committed also on them. So it would go into 2 lanes, the whole thing. In the last transactions, the same thing. He sells the house, receives the dollars, and those dollars now are the second surrogate, which is still in place for money laundering. It's contaminated and can be confiscated by the police. However, on the person D side, it again depends on the good faith while acquiring the house. If person knows about the criminal origin, the assets remain contaminated. If acquired in good faith, the assets become clean and out of scope for money laundering. As mentioned, it is not yet a confirmed theory, and maybe in the questions section I would be interested to hear your opinion about it, or maybe there are already solutions in other jurisdictions or confirmed solutions in other jurisdictions about that issue. Next issue, maybe even a bigger one, is the problem of commingled funds, meaning both criminal and clean origin coming together. Again, a very simple example. Funds of a criminal origin, 1 million dirham, funds of a clean origin, 1 million dirham, together on the same account of person X. Person X transfers now 1 million dirham to the account of his wife, which she holds for him, so she's a straw person. And now is the question, has the person X committed money laundering or not? So are these 1 million dirham that he transferred to his wife, are they of criminal origin or not? So again, we must always think about what money laundering means. Criminal origin. How can we locate the criminal funds on a mixed account? So there have been a couple of theories that have been developed in order to facilitate this. Those are the following 4 models that I find the most promising, however, they're not the only ones. So the total contamination model is a quite simple one, very easy to understand. As soon as criminal proceeds are mixed with clean funds, all of the funds are considered tainted and all of them are up for confiscation. It's a very clear rule, but meaning that at some point the police could confiscate the entire economy, because we saw what extensions the money laundering takes with 1 trillion in the global economy. So this is a model that has been refused by many scholars because it's too extreme. Another model would be the percentage model, that according to a certain percentage, even though it's all considered contaminated, but only a certain percentage can be confiscated and only a certain percentage can be considered as money laundering activity. You get it from what how I'm trying to explain it. It's way too complicated and not suitable for complex transactions. It will benefit again only the criminals, especially considering when you do this over 10 transactions. The 2 more promising models are the last in, first out model, meaning the criminal proceeds are the ones considering going the last into the account and the first ones out of the account. And that one is one that we will look at in the example, and the opposite of it is the so-called floor model, meaning it's just the opposite of it, meaning the criminal assets are the first in and the last out. So what does that mean for our example? If we look at these, depending on which model we use, person X transfers 1 million dirham to the account of his wife. If we follow the last in, first out model, meaning that 1 million dirham is considered the one on the top. Of these 2 million dirham, the 1 million dirham that is transferred is considered of criminal origin, meaning the person has committed money laundering. If we use the floor model, the 1 million dirham that is criminal is on the bottom of the account, and the first 1 million dirham that are spent are of the clean origin, meaning no money laundering has been committed in this example. So depending on which example we use, it's either money laundering has been committed or not. It is a bit of a question of taste, which model you prefer. I personally believe that the floor model is the most suitable one and the fairest one, but happy to discuss it. And in particular, interesting this whole thing becomes when we talk about tax crimes. It's the same principle that applies, but with tax crime, you do not receive criminal funds. The criminal funds are in the savings. They are already on your account. So meaning, as soon as you do not have to pay the tax because you fraudulently denied to do so, all of a sudden, the funds you have on your account, some of them are being considered of criminal origin. But then the same principles as we discussed before apply. The taxes are in particular interesting for the UAE and for Switzerland as tax havens because it's not only local tax felonies that are considered, but also tax felonies from abroad, which in Switzerland has happened a lot in the past. Just a quick summary of the whole thing. And despite its long existence of the provisions, we have seen that the money laundering has not yet answered all the questions that have resolved. In practice, we face a lot of issues that make it difficult to convict people of money laundering, despite the long-standing practices we have and the various funds we have put in international organizations. Due to the international nature of the money laundering that we are seeing, those questions we've just talked about, I do not think they can be resolved on a national level, but must be resolved on international level in order not to create jurisdictions that are favorable for money laundering and then are chosen by the criminals. Thank you so much for your attention, and I'm happy to discuss questions with you.
Do we have any questions?
Well, hello, Michael. It was a very insightful presentation, I must commend at the outset.
Thank you so much.
With respect to the factum of commingled funds that you discussed, I would like to know, as to the jurisdictions you are referring to, how are attachments during the course of investigations dealt with, like in the case of that $1 million example that you took, when the investigations are underway. So with respect to the attachment, because the ultimate adjudication may take some time. So how are they handled?
So I can just speak for Switzerland, but they would be temporarily confiscated if there is if there's a suspicion that the funds are of criminal origin. However, then it would be on the criminal authorities in order to prove that only the criminal proceeds or of criminal origin assets have been used. So in the first step, it would be all confiscated as soon as we have the criminal origin on it, despite of all of these models. So the whole thing would be confiscated in the first step.
Okay, just an add-on question there. In case that this attachment is there and the related party subsequently become insolvent, then for the creditors, what is the distribution matrix?
So that means that we were talking about a civil case now. So that would not be such an issue, because then the funds would then be liquidated, and then they would be given to the respective creditors. The creditors do not know about the criminal origin, or at least they shouldn't know, and then we can move it with the lacking intent or the lacking knowledge. None of the creditors would commit money laundering. unless, of course, it's all a big scheme, which has happened, that they are fully aware of it and distributing the criminal proceeds via a bankruptcy.
Thank you.
Sure.
All right, thank you so much, Michael, and would like to present a memento to you. It's such a valuable contribution. Thank you so much. Thank you, thank you.